The Mighty
is,
Quinn from the band Bob Dylan song.
that is not a streetcar named Desire name. I'm sorry to tell you.
Quinn brings joy to despair and peace to chaos.
Are you gonna sing again, Whitney?
Urine to every corner of my new house.
Okay, I'm going to go ahead and call roll just because I think that's easiest for us to take the minutes. So if you're on the commission and if you're not on the commission, if you're not a commissioner, please mute your button. And if you are on the commission, please unmute. Channing Jones. I think I saw Channing on. Channing, you there? I thought I saw him. Anyway. Dorothy?
I'm present.
All right. Caitlin?
I'm present.
Stacy? Stacy Rubain? Staple Hughes? We may not have a quorum yet. Judge Menifee? And Pritchard? Russ Anthony?
Present.
Brian Jones? Brian Cromwell?
Present.
Art Beeler? I think I saw Art. Yep.
Present.
And Judge Cross White. All right. I don't think we have a quorum yet, do we? We have to have a majority.
Right.
How many do we have, Whitney? I didn't mark them as I went.
Darren Channing Jones is present also.
Okay. Channing, is that you? Okay.
7, including you, Darren.
All right. Olivia, if they start coming in, will you let us know when you let one of the commissioners in, please?
Yes, absolutely.
That way we can mark it. So we have a quorum now.
Did I hear Brian Jones present or not?
I did not hear Brian.
That was Channing Jones.
I think that was Channing.
Yeah, I don't
Staples
see a
just
Brian
showed up.
here.
Guys, Staples is here.
Staples is here. All right. Okay. All right. Well, we'll get started. Thank you guys for
We have 2
joining
Brians,
us.
2 Joneses.
I'm sorry. Thank you for joining us today. We'll call the meeting to order. The first thing I want to do is read the State Government Ethics Act, and then I'm going to allow Whitney to give us a reminder about the State Ethics Act. Members of this commission are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest and the appearance of conflict, and are instructed to refrain from participating in any matter coming before the commission with respect to which there is a conflict of interest or an appearance of conflict. I think that Staples, you usually note a conflict. Is that correct? You need to unmute.
I'm on the NCPLS board, and only if there's something on the agenda that concerns NCPLS do I make that notation.
Okay. All right. Are there any other individuals who want to note any conflict? If not, at this point in time, if something comes up, if you will please chime in and let us know so that we can the minutes can reflect that. Let's see.
Darren, this is Art.
Yes, sir.
If something were to come up because I'm a temporary employee at DOP that would be in conflict with DOP, I would recuse myself. That has not happened as yet, but if it did happen, I would have to recuse myself because of that. And, you know, when we get time for the go-arounds, I wanted to just give a shout out to Beth Cook, who is the new PLS Executive Director. She is, not that Mary wasn't wonderful, But Mary, you can smile. But that she has been wonderful in getting some data to us in our desire to become ACA accredited. I don't need to explain all that. Mary knows what, and Whitney knows what I'm talking about. But she's been wonderful about doing that, and I wanted to give her a shout out because I don't even know if she's on this meeting or not, but she's done a wonderful job helping us.
All right, thanks, Art. I'm going to actually dispense with the introductions because it's so difficult with this Zoom thing. The minutes of the December 13th, 2019, April 24th of 2020, and June 18th of 2020 commission meetings are in your packet. I hope that you've had a chance to review those. I've looked at them, and I think Dorothy's looked at them as vice chair, and we think they're in order. Does anybody have, is there a motion to approve those in a second? If so, raise your hand. All right, Art and Dorothy seconds it. Are there any discussions or amendments or anything at this point in time to those orders, those minutes? All right, if not, if you will, let's do this. On your participation bar, if you hit that at the very bottom of it, if you're a commissioner, how about let's using this, the yes and the no, and mark it. And if you can't find it, let us know. But all in favor of the adopting or accepting the minutes from December 13th, April 24th of 2020, and June 18th, hit yes, please. All who oppose, say no.
Darren, I've been here the whole time. This is Brian Jones.
Okay, welcome, Brian.
This is my first Zoom call, so I had a little issue with the mute and the other button, but I got that figured out. So I'll be a little slow to the punch here. But
Do we have those recorded, Whitney?
Yes.
All right, and that passes. All right.
Darren, may I make a suggestion really fast to be helpful? Because I know Ms. House or whomever is trying to make sure they tally up votes and things like that. We may need to have all the commissioners to maybe put commissioner some kind of way in their name to push it up so that she can see who all are commissioners and be able to tell the difference between the votes and things.
That's a good. Do you want to tell everybody how to do that?
So if you all open up the participants tab again, like what Darren just stated, and then when you go to your name, if you scroll kind of over, put the cursor over your name, you'll see a button that says more, and then you can do rename. And I would say put IDS before your name. That might make it easier. That way she can be able to see those, and they should all, then it'll group them together, or it should group them together.
It's a great idea. Thank you.
You're welcome.
Okay, so I got that. I'm at the, I hit more. And did you say raise hand?
No, go to more and then go to rename. So you go to your name and then put your cursor, your mouse over your name, and you should see two buttons. One to say mute, one say more, and then put more, and then do rename, and then scroll to the beginning of your name. And just like what I put in mine, I just put IDS hyphen.
Gotcha. I'm doing that right now. Thank you.
You're welcome.
Thank you, Dorothy.
You're welcome.
All right, moving down the agenda. The adoption of proposed agenda, you guys have seen that. There will be a couple of things that we will alter as we go through. Do I have a motion? If so, hit your raised hand in a second with regards to adopting the proposed agenda. All right, we have a motion from Brian and we have a second from Channing. All in favor, hit yes, please. Whitney, did you clear out the yeses from the last time, or can you?
I don't.
Dorothy, help.
Yes, I just cleared it, but now there we
Okay.
go.
All right. All in favor of the adopted agenda, please vote yes. And all opposed, say no. All right.
We have a majority. Yeah.
That passes. All right. I want to make an introduction. This is where I'm going to alter the agenda just a little bit. I want to welcome new commissioners, Gus Anthony. Gus, you on there? Give us about a 2-minute introduction of who you are and how you came to be here and what kind of practice, where you're from, sir.
Thank you. I don't know if I have 2 minutes worth of interesting stuff to share with you, but I'll give you all I got. I'm an attorney in Gaston County. I've been started my legal career in the public defender's office here in Gaston County. So indigent defense has been a big part of my career for the last 24 years. I'm still on Rob's list at the Capitol Defender's Office. I have been handling those cases since I went into private practice in 2000. And this is very important to me. I didn't realize how this part of the process worked. And this is interesting to learn what goes on behind the scene. Just a little bit I've learned already. And I'm looking forward to being part of this process and trying to help all the people across the state that handle cases like this, help them best we can. I'm looking forward to that challenge.
All right, thank you, Gus. And Gus is the appointee from House Speaker Moore, his office. So welcome, Gus. We appreciate, and he's taken, for the lack of a better word, he's taken Mark Hollander's spot on the commission. Brian,
Excuse me, Darren.
Yes,
Gus,
sir.
could you tilt either your laptop screen forward or there you go.
All right. We're learning, baby. We're learning. So Brian Jones, you want to give us a little 2-minute blurb on you, buddy?
Yeah, Brian Jones. I'm in Morganton. Started my legal career with the district attorney's office in Pender County, and moved to Burke County, Morganton, North Carolina. Started working with the district attorney. Really dove in, lasted a full 9 months, and then moved to private practice. And so I've been on the list for probably 16, 17 years. And from Wilmington, North Carolina is where I grew up. I've been here in Burke County for about 17 years, and looking forward to hopefully bringing something to the commission where I can help and serve the state of North Carolina. And I'm glad to be here and glad to be with everybody who I've seen on emails and listservs, and it's good to be here. And if anybody needs anything in Morganton, I'm happy to help.
Thank you, Brian. Brian is the appointee from Senator Berger's office. So welcome to the commission.
Thank you.
I want to, at this point in time, recognize and congratulate our new executive director, Mary Pollard. And Mary, I'm going to give you the floor to do your report, please.
Thank you. I'm glad to be here. Darren asked me to give a little report of what it looks like 90 days in. And I'll tell you, it's been challenging starting a new job during the pandemic, and the staff has been really great. I hate that I'm having to get to know them often through little boxes on a screen, just like we're doing right now. But it's working. It's working. I've appreciated very much Elisa's educating me on the budget and all of the fiscal issues, and Margaret Grasson's in particular educating me about the data and the capabilities and the promise that sort of her expertise holds for the work I'd like to get done as executive director. So at this point, I've gotten to know all the staff. I've met with all the state defenders and talked with them about their issues and their concerns and how I can support them. I've also been invited to and presented at the House Select Committee on Community Relations on Community Relations, Law Enforcement, and Justice at the General Assembly, and to the Superior Court Judges Conference. And I'm also participating as a member of the Governor's Task Force on Racial Equity in the Criminal Justice System. And those have been great opportunities. First of all, every time I talk to anybody, and I will continue to do this always, I educate them about IDS and our lack of resources and the unsustainably low rates that we're paying private assigned counsel. So On the governor's task force, in addition, I'm learning about some potential initiatives that will affect how we do our work and might cost us some money. So I'm glad to be abreast of that, and in addition to participating in the very important work that task force is doing. So I hope to, I'm going to work with you all as a commission to do some long-range planning, and we'll talk about that more later today. But I wanted to tell you just about kind of the big projects that are at the top of my agenda and that I'll be reporting back on sooner rather than later. The first is the public defender selection and retention statute. I know when I interviewed with y'all, I talked a little bit about my my vision for the selection, or I guess really the retention of the chief public defenders, and trying to get to a system where they have more independence from the senior resident. And I've also learned a lot more about how the selection statute, it has to be corrected. It's there's a couple of issues with it, technical corrections that simply have to be made. For example, it doesn't provide for how to select a chief public defender when the public defender's district spans several judicial districts, right? So you have multiple senior residents, and we're not really sure how that works. Hopefully it will just work out okay. There's this sort of silly provision that requires the local bar to submit 2 or 3 names to the senior resident. Even if the public defender is absolutely fantastic, nobody wants to contest them, there's no serious issue that they should be retained, they have to have a straw man vote and submit and that just seems kind of silly to me. There's a provision that requires me to consult with the director of AOC to submit a name, and some judges read that as us having to submit an additional name. So that puts me in a position of having to submit a straw person, I should say. In a situation where we have a great chief. So that all needs to be fixed, but since it has to be fixed, it might give us the opportunity to make some bigger changes to how we select and retain defenders. And I'm working with Susan Brooks, who is researching best practices from other jurisdictions, and we'll work with the public defenders themselves and their committee to try to come up with something that that works and that makes sense. And I expect we'll report back to you early next year on that, because maybe it's something we can get done in the long session, being optimistic. The other big project that we'll be working on is that it's time to assess the usefulness and effectiveness of our contracts program for adult, criminal, juvenile, and parent representation. And Margaret is taking the lead there. We're going to figure out, is it cost effective? Are we saving money? And are we getting better client outcomes with the contracts? And we'll have to look at the results of that and see if we need to change the program, amend the program, get rid of the contracts program. I don't know. We'll have to see what the data shows, but it's time to look at the data so that we have a good understanding of the utility of the programs, the contract program. And again, we'll be back to you in the first part of 2021 with the results of that and recommendations.
And Mary, I don't mean to speak out of turn, just to let you know, I'm in a jurisdiction with those contracts. I just want to note that. And that way, if you have any questions or want to say anything, and again, this is my first Zoom call, so I may be out of etiquette here, but just want to let you know that.
No, I appreciate that. And if you're volunteering to be on the long range planning committee when we revisit the contracts, that's excellent. So.
Oh, yes, ma'am.
What else am I looking at? Okay, so we'll talk a little bit later today, or maybe we won't, about long-term planning for expanding public defenders' offices in a rational and cost-effective manner. If we're going to do that, that's on my agenda. Some minor attainable things, because I like to be able to do some things that I know we can get done, so I can come back and tell you what a great job I'm doing. We're going to get the website redesign finished. And it's 90% there. I hope to get it up and running soon. We need a little bit of outside help, I think. I want to see the website really be, and it will be, more functional and more useful. And I want to do things like have our rules and policies indexed and searchable, right? So it's just easier to navigate. What else do I have on my short list here? Tucker and Jeff have some fantastic ideas about attorney training and support and building community with private assigned counsel. So I'm going to work with them to make that happen. And then it's time for us, I think, to update or to look at updating, or whether we need to update IDS rules, IDS policies, and the performance standards that are posted on the website. Because some of them have some age on them and go back to 2004 or something. So it may be nothing's changed, but it's always, I think, a good idea to revisit your policies and ascertain that every 10 or 15 years. So those are, I think that's achievable and doable, and we should be able to get that done in short order. So yeah, I look forward to working with all of you. I expect we're going to be doing some committee work. I expect to work with the Personnel Committee between now and the end of the year, because y'all have some state defender evaluations to do at the next meeting. Expect to work with the budget, or the Legislative and the Budget Committee, on some of the issues that Elisa and I will be covering later on in today's meeting. So that's my report.
All right, thank you. Does anybody have any questions or comments of Mary? Other than, Mary, we're glad to have you. We have a extremely incredible team up there.
We do.
Looking forward to it.
I do have, if I could, Darren.
Yes.
Welcome again, Mary. And I just wanted to take a little bit of, if you could give me some indulgement, take a little bit of privilege. I know we're in the remarks from the chair, but I would like to make some remarks as the vice chair. And I'm not sure if everybody is aware, but you should have been aware by now, that our wonderful Darren Jordan is now our president-elect of the state bar. And he will be in leadership along with Barbara Christie, who is our president for this year moving forward. And we are extremely excited. I thought this would be something that you all would like to hear here at this meeting too. Darren is not only providing great leadership here for us at IDS, but he is also providing, and has been for many years, providing great leadership over at the State Bar Council. And I just wanted to make that announcement and give him that little bit of acknowledgement that he was not prepared to get right now, as you can see on his face. But I at least wanted to and say that here today. So if you all could just join me and welcome me. I'm congratulating him.
Bravo.
On that accomplishment.
Thank you.
You're welcome.
Thank you. As they say in my neck of the woods, even a blind squirrel finds a nut every now and then. So anyway, thank you, Dorothy. Let's move to Alicia. I think she's on here, and I think she's got us a PowerPoint, and this is the financial report. So Alicia, I'm gonna hand it over to you. You need to unmute yourself though.
Maybe. Okay. And I'm going to try to share my screen. So let me make sure that's going to work. Okay. That seems to work. Can people see my screen? My PowerPoint?
Yep.
Okay. I did ask Darren at the beginning how long he wanted me to talk, because I know I can sometimes go on for a while about the budget and all the different details of what we're spending and how we did it. And, I get the opportunity every fall, and I think I do tend to talk about a lot of trees and details and little things like trends and low-level felonies, things like that. This year, I'm going to try to focus a little bit more on the forest, in part because, the details of what we did last year is less relevant because last year was so abnormal. And, so it's sort of comparing trends and things like that is just not as much useful to you. The reason we do an overview of our budget, looking at past spending and other things with you each fall is to, just geared at decisions that the commission or discussions the commission may want to have. There's been times when we've had funds available in the budget and you've been able to talk about very targeted rate increases. Those are good times. There are times when we talk about having a projected crisis of a shortfall, and then we're having to talk about how to manage it, how to mitigate the damage. Are there other ways we can save money to try to plug that hole in the PAC fund? And then in general, because all this time we're dealing with a completely under-resourced agency, we're always talking about strategies to develop more support for resources for indigent defense. And so sometimes knowing about where the spending is helps in that. So I'm trying to keep in mind the purpose of all these details rather than just give a lot of numbers. I sent out a short sort of memo with the advance packet, and because the short story is we are very unlikely to have a budget shortfall this year because we're spending much less than we normally would because of the slowdown in court activity, that the majority of our spending is driven by court dispositions. If the rest of this year acted like 2019, which was our last normal year, then we would probably have a balance of about 4 million. That's just sort of the minimum. If the rest of the year is like the first 4 months have been, then we'd be talking about a $14 million balance. I don't think that would happen. That's going to be what happens, because that would suggest much more dire situations statewide in terms of recovery from the pandemic. And is this unusual? It's very unusual. I mean, we've had for the past 4 years, even last year with the court system proceedings sort of slamming to a halt in the end of March, it really ended up looking a lot like the prior 3 years, where we finished the year with a small amount of unpaid bills. There's as much timing as anything else, and then a small amount of revenue that came in too late for us to spend. And so it might be that we slow down our payments for a week or so, but nothing significant, and nothing significant left over. Until 2017, and I think there's fewer people in the call who lived through that, we ran significant shortfalls, including 2 years of back-to-back $10 million shortfalls. So to say we're looking at the possibility of significant funds left over is an unusual thing. And that money, it's not like we get to keep that and carry it forward, although I think that's one of the strategies we want to talk about, because trying to use that situation to look at the next 2 years, as the further along we get into looking at living through the impact of the pandemic and its impact on the courts, the more I'm talking about not so much this year, but the year after and the year after that. Because as we continue to see what we think is a backlog in cases, and knowing that the limitations on how many cases the court system, even in normal times, can process in a given time period, that we're talking about this spreading over several years. And I have no data on this, but my biggest concern, and again, I think this is having lived through the years where IDS spending just went up and up every year, is an increase in indigency rates, reflecting what's happening in the state's economy and unemployment and other disruption. That would have a very big impact on the demand for indigent defense services. And I've been using the word train wreck, but I don't know that. It's just, that's my concern, is this year is not the crisis that it's probably down the road. Just this is as much benefit for new commissioners, just the big picture. Our current year budget with all sources, including county funding, get over $1 million from Mecklenburg County, is about 140 million. So that's basically the size of what we have. The largest piece of that comes from our general fund appropriation from the legislature, which is unchanged from last year. And as you can see, it's hard to compare numbers for a different year. What we actually spent of our general fund appropriation last year was about 125 million. And where does it go? The single biggest use of our funds is to pay private attorneys on a case-by-case basis on fee applications or by contracts. Also through that same we call it our fund, we pay a significant and growing amount to experts and other support services for private counsel in all kinds of cases. The second biggest use of our funds is personnel costs in our defender programs, both the local programs and the specialized statewide defender programs, and a very small amount on our what we call administration. I cannot believe there's another agency with a smaller percentage of their budget going to administration. Our operating budget in the defender programs is very small and very lean. We don't generally have anything left over from that amount of money. And of course, the counties contribute to some of the costs in local defender programs.
Alicia,
bring you down a little bit more.
Alicia, can I ask you a question? Can you go back to that other slide? You may be getting into this. I mean, those figures do not include the public defenders or the contracts.
this is everything we do. So the first line, private assigned counsel, those are the payments, those are the fee applications and contractors. Defender office personnel costs and other costs, those are the total costs of what we pay public defenders.
Okay, so the contracts
So
are
this is
included in the private assigned counsel.
Yes.
Okay, all right, sorry.
And I break that down a little bit later. I'm sorry if that wasn't clear. Of our costs of defender programs, of course, it's the local defender programs where we have 300 attorneys doing direct representation in 35 counties is the biggest piece of that, and smaller amounts for our other programs. Capital Defender's Office costs are higher in part because they have 6 offices, and also because their budget includes a more significant amount of costs like experts and mitigators for cases that their attorneys handle, compared to, we have some of those costs in local defender programs, but not as dramatically. Looking at, I think this goes to Darren's question, looking at the cost of private assigned counsel, about 7.6 million of that is the contract system for adult criminal contracts. We have 155 different attorneys on contract, not full-time, but who are doing that portion of the private assigned counsel. We also have contracts with 2 organizations, Prisoners Legal Services and Center for Children's Rights, where we're paying them as an entity to handle a certain aspect of indigent defense. And then we have a growing amount for parent representation contracts. And then also it's been growing, but it's a smaller total for delinquency contracts. I think that was an area we anticipated increasing with Raise the Age, but of course that came almost simultaneous with the pandemic. Fee applications this is our biggest chore and our biggest, I don't mean chore in a bad way, I mean our biggest activity and a dollar impact, with adult, district and superior court, criminal being the single biggest piece of it. And then this shows sort of the small amounts for everything else. So when I look at trends and try to predict them, I'm much more concerned with this first item than anything else. It's the most volatile and it's the biggest piece of it, that a 5% increase in non-capital appellate spending is not going to affect our ability to do other things just because of the dollar levels. I did want to mention a little bit about capital related spending. This data is a little different because it's coming from our own database, which looks at the cost of capital cases, both those handled by private attorneys and by assistant public defenders and assistant capital defenders. And we had been, watching a trend of increasing costs over the past couple of years. But I also, for this year, I think this is a good illustration, both of why I feel I'm never confident, but relatively confident we're not going to have a budget shortfall this year, but also worried about a train wreck down the road, because those cases don't go away. So eventually we'll be paid for. But in the first 4 months of this year, we've spent first 4 months, that's a third of the year, 2.6 million on capital trials. Of course, there haven't been any. Attorneys bill interims along the way. But at that rate, we'd be, if this continued all year, in capital trials, we're going to be among the harder to resume. We'd be talking about spending 7.5 million instead of what's been over 12 million for several years. So if that's our only savings compared to prior years, that's big. That means funds available there. But the other thing is those cases are going to come around eventually, and that's why it's one that a savings this year is just a problem next year if you're looking at dollars. Just very briefly on what we call IDS administration, a big chunk of that are folks who process fee applications, accounts payable. We also have a set-off debt program that's receipt supported that administers that program, intercepting tax refunds and lottery winnings as required by law for outstanding judgments on former clients. And then this sort of briefly lists the staff we do have and what's more administration policy and support for attorneys in the field, both PAC attorneys and public defender programs. I just want to talk a little bit about, I was looking at dollars. This is looking a little bit at how many cases were handled. It's always hard to do this because, you know, in public defender office, we're counting dispositions. When we're talking about private counsel, we're talking about counting fee applications. And with contractors, we're usually talking about dispositions. But our local public defender's office reported almost 80,000 cases disposed of. Because they only report dispositions and withdrawals, it very much understates the work of those offices. But in that, those can range from involuntary commitment proceedings to B1 felonies, and included 133 jury trials last year among our programs. And they have a caseload that includes 234 first-degree murder cases. So they really run the full gamut. The numbers for our specialized defender programs, you know, the special counsel is the high volume program doing the involuntary commitments at state facilities. And then the numbers for the more time consuming cases handled by our appellate defender programs, the capital defender. And we have 2 people in the Office of Juvenile Defender that does more policy than representation, but that they do handle some cases, and that is reflected there. Just a quick note on, it's always hard to present the public defender disposition numbers. Nobody has any surprise that they're lower last year, of course, but that, you know, there's been a downward trend for many years, although the offices are just as busy. And it's, you know, we haven't solved that issue of being able to explain those numbers. And so we try not to put too much weight on them because we know they don't reflect what's really going on. Like the rest of our system, you know, the majority of the work by count is district court, and there is a significant and I think growing amount of work done on civil cases in our defender programs, child welfare, and involuntary commitments. We do, when we talk about public defender dispositions, and I try to remember we like to talk about a weighted disposition. And if we're looking at our spending in the PAC, we know what's a more serious case because it's a higher dollar fee application, but a public defender disposition, 1 is a 1. So we do have a way of converting that to a weighted number where it's weighted based on the relative size of a PAC fee application. And then just a little bit more detail on the kinds of cases we were paying for. This shows the number of dispositions reported by those contractors under the RFP system. Of course, misdemeanor being higher volume. The numbers reported by our, we call them individually negotiated contracts. And then just, again, like every place else, district court is the bigger volume piece of the appointed by case, paid by case fee applications. And these are last year's figures, so they differ a good bit from prior years. So what does this tell us about this coming year, and how do we move to projecting what we have available? One of the pieces of it is our recoupment receipts, which if they're part of our budgeted, what we have available to spend, but if we don't get them, we can't spend them. It's spend about $10 million a year, relatively stable, with a growing piece of that being from set-off debt and a shrinking piece of it being through the clerk's offices, which is people paying at disposition or time to pay or through probation. I expected those figures to plummet last spring when there were no court proceedings, but they didn't. I mean, they went down, but not, and I'm like, where are they coming from? And a lot of it was, I guess, people still on probation, under probationary supervision, and all the online options that people have to pay different fees. I don't know. We always have trouble explaining where the recoupment receipts come from. We just get a daily deposit without any detail as why. If I look at the first 3 months of this year compared to last year, we were down 4%, which doesn't seem as much as I would think it would be. But that, of course, could change down the road. Set-off debt is impossible to predict. Nobody can model who is going to get a tax refund or win the lottery and whether they have an outstanding judgment for court's fees. There's no historical data other than that it has gone up a little bit every year. And then in terms of recoupment, the one change that is in our budget, the very, very short session had took action and increased 2 fees that come to us. One is the appointment fee is increasing from $60 to $75 effective December 1st. And the other is there's a brand new $2 court of justice fee that everybody will pay who has a court case. You know, my kid with a speeding ticket not just for the first time having a fee that's not limited just to court indigent clients. How much is that going to bring in this year? I mean, like anything else, it depends on court activity, but also if not all fees are being paid, raising fees doesn't necessarily bring in more. We're on the bottom of the priority list of the various fees clients have. In particular, the appointment fee. A significant amount of our receipts from appointment fee come in through civil judgments and set up debt. And so there's not much of an immediate effect for something that happens in December. I had to do a projection for state budget, and I projected it might mean, I think I have about 800,000 for this year could come in from those two fees, but I'm not sure. And then could be more like 1.7 million in a full regular year. So that would be an increase in the recoupment piece of our budget. There has been no increase in the appropriation. There was in the 2019 budget. That budget was vetoed, and that piece of it was never resurrected. So we had not had a change in appropriation, despite some very valiant efforts from our JPS chairs. The other significant source for our budget is funds that start out for the Defender program or IDS administration, but aren't spent. Vacancies, things costing less than we thought. And most of that's what we call lap salary, and that can be from vacancies, but also we do control it. We do not allow our public defender programs to spend their entire salary budget, because the PAC fund has always relied on expecting $2 million to transfer in at the end of the year. We have some smaller funds that come in. I think we get a Cypre award every year, but sometimes it's 2,000 and sometimes it's 700,000, and we can't predict that. We've had small grants. Most of our external funding is for positions provided for by the county. We are working on getting federal funds that should be available to us for representation in child welfare cases. That's a long project, and I'll talk a little bit more about that at the end. This year, we got some very helpful funds to provide laptops to all that from the COVID relief program, federal funds through the state, to provide laptops to all our staff who didn't have them and were really struggling to work remotely. So that's about a $600,000 gift we got for that. In terms of other sources looking in the other direction, if the state's financial picture deteriorates, state budget is responsible for making the whole state budget work, and they can ask agencies to slow down their spending or give back some of their funding. That has happened in the past. It's been a number of years. But I think at this point, no one is expecting that this fiscal year. That next fiscal year is where the state's financial picture is expected to be worse, more dire. I think the funds left over from last year carried over to this year by the state have really make this state not a crisis. Yeah, that can change quickly, as we know. The other thing, of course, that can cost us money is litigation. Just talking a little bit more about the difficulty of projecting PAC spending. The contracts, there was really some wonderful things about the contracts right now. One is when nobody else was getting paid, our contractors were getting paid. I mean, that's the nature of the contracts. And so I was very grateful for that last spring when I was aware of how many of the attorneys who do our work were not getting any income. They're also easier to predict. Like I know that adding up all our contracts across the budget, it'll be, 12 or $13 million. I don't have to worry about public health emergencies in court slowdowns, necessarily affecting that. There's some noise around that. There's overages and shortages, but still it's a relatively predictable spending stream, for which I'm grateful. The opposite of that is the non-capital fee applications, which can vary from month to month in a way that we have trouble explaining, or certainly can't predict. Some of that's underlying patterns in how quickly courts dispose of cases, and some of it's variation in how people bill.
Alicia, can I ask you a question on the contracts? The contracts are paid on a guarantee of dispositions, is my understanding. How did we handle that when nobody was disposing of cases?
What it is, I'm probably not the best one to tell the details, but there's a range of cases that are expected, so it's not an exact number, but yes, that has been an issue that we have been addressing. The contracts are 2-year contracts, so there's a period of time for which to smooth over those things. And there were contractors who were well ahead of their target dispositions before the slowdown, so that at the end of the contract, they were okay. And there was a relatively small number of them who at the end of our original contract period were behind, but we extended those contracts in some part because of that. But somebody else would be better to answer that.
All right, thank you.
Did I cover the gist of it?
This is Tucker. The contracts are not based on dispositions; they're based on case assignments. So, as far as the contracts go, it doesn't matter if somebody disposes of a case rapidly or takes a length of time. The contracts are not based on dispositions; they're based on assignments. And someone's assignment can take them past the termination of a contract, but it's based on we have a weighted system. Based on your open cases and your closed cases as to where you are in the contract term.
Okay.
So the dispositions didn't affect them. They didn't have to dispose of a single case, and many of them didn't. In the last couple of months of the contracts under the last fiscal year, that didn't matter because they were still getting cases or they were still contracted and were still within the contract range. And that comes from keeping an eye on the keeping an eye on the assignments, and we had to make some changes around December before the pandemic because the cases were already dropping for whatever reason. So we already made adjustments. So when the pandemic hit, we had to make further adjustments, but it wasn't as bad as it could have been because we kept an eye on things.
All right, thank you.
And I appreciate Tucker for correcting that too, because the other thing I wanted to stress about contracts, and when we think about looking ahead, is contracts prepay, that we pay somebody over a period of time, and then if they have cases that have been assigned and not disposed, they will dispose of them in future time periods. And so every year we have cases that are disposed of that we're not paying for that year because they were prepaid through a contract. And that was another advantage of the contract system. If we're worried about a backlog of cases and funds to pay for it, some of that backlog of cases we're not going to have to make new payments for because they were prepaid. One of this shows, and I think some of what Tucker mentioned too is a little bit of this. This is looking at what we've paid. This is just looking at trial level, the district and superior court non-contract criminal fee applications. I know those of you on the commission last year was very concerned about much higher level spending than we anticipated and that we couldn't afford, really up until March. And we at the time didn't really know where it was coming from because we just knew we were getting all these fee applications. It was both the workload volume itself was an issue because we were getting slammed with fee applications. And this shows now in going back, we can say, well, not when did we pay those fee applications, but when was the case disposed of based on when we process the fee application, we record what the disposition date was. And you can see, just going back, there's that big dip in September 2018, and that was a hurricane. And you could see it in the dispositions. And then you see sort of several months of higher than trend dispositions late last summer and fall back in 2019, and that was what we were seeing in terms of our costs most of last year all the way into February or March. And I don't know why it was higher, and I don't think it had anything to do with us. I think it was just that things that are going on in the overall court system and law enforcement and everything else can give us some unexplained and therefore unpredictable trends. There were two things I also want to talk about looking at last year's volume of work. Interims is never a major part of our spending, but it's always, except capital, where there's we want them to build regularly and not just at the end. But we definitely saw a significant increase in what we paid last year, mostly in the last 4 months of the year, that was interim payments. And, this sort of shows looking historically what we would pay as interims. I think Superior Court's the more dramatic. Usually about 1.7% of our fee applications were interims and about $500,000. That more than doubled, both in terms of percentage and dollars for last fiscal year. And that was because we worked, I think a lot of judges worked, to encourage interims, both to not save all that. I mean, attorneys had time in a case. The position was scheduled in April. Maybe it was scheduled in July of this year, but it was certainly in our advantage to pay as much of that time last year when we had the availability. And also because for attorneys to have to wait for a disposition when it was completely unknown when that might be, just wasn't fair. So I think when we were successful in using that tool, both to help the attorneys and to spread out the costs. It's a little early to tell whether we're continuing to get a lot of interims in 21. The other issue we're trying to look at is withdrawals. I mean, there's always withdrawals for various reasons. We're trying to watch it to see if it's attorneys leaving the list, which would be an issue for us in having the list robust. Again, it's something we're watching that I don't think I have conclusions of. The other metric that, I wish we had good data on is we feel, and we certainly hear anecdotally from our public defender programs, that there's a backlog of cases. In the spring, there was a big drop in filings, a big drop in dispositions, and the filings went back up a lot before the dispositions. And I know in our defender offices, they talk about they continued to get new cases at a similar pace, but didn't finish any of the pending cases. But I don't have good data. I tried to use the AOC data that looks at the counts pending cases at various points in time, and state in our defender program counties there. If you look at those statistics, it's about 6% higher June 30th of 2020 than it was the prior year. Whether that number means anything yet, it's a little hard to tell. The other thing we don't have data on that we were hearing anecdotally were prosecutors dismissing minor charges. Whether that was more or less true with court-appointed clients, we don't know, or whether that was just anecdotal or certain counties or not. But again, that's not something I really have good data on. I might know some more.
Lisa, the previous two slides back, there was that one. Could you just give us 40 seconds of what 71% of capital FY21 interim, what that means, please?
I guess I just want to say that we've always had interims in capital cases. In appellate cases, there's always an interim and then a final. I mean, the interim's the big one and the final's the little one. So I didn't really look at those areas in this. I don't know that frequency of interim is significant for the capital, but maybe I shouldn't have put that there just in case someone would ask about it, I guess. So I mean, I can talk to Rob and Margaret Mary a little bit more about looking at the trends there, but I was more looking at the trial court.
Got it.
So, I mean, I think. Okay, so those sort of the purpose of all that is, if we have available funds at the end of this year, and I don't know if other people have information that will tell me that's a crazy idea, that I think we're going to have available funds at the end of this year. There's a lot of unknowns, but it is almost November, and every month where I sit, every month we go, there's less uncertainty. If we knew that was a recurring thing, that next year's budget would also have available funds, that's when you can talk about rate increases. Because if you raise the rates, if there's an increase in court-appointed hourly rates for attorneys now, we have to be prepared to pay for that in future years on an annualized basis. So availability this year doesn't necessarily mean we can afford to do that without a risk of shortfalls in the future. What short-term availability can be used for is contracts that have an ending date, temporary employees, one-time purchases. In our public defender programs, we're not spending much on travel, but most years I can look at our budget and say, okay, I can replace 3 old copiers in the field and buy 1 car. you know, it's like, okay, you know, find a little bit of money to do those things that save us in the long run. So we'll probably look at that if there are places where, because once you buy a car, you're not paying the monthly, you know, mileage stuff. And I think a big area of that is like, it probably doesn't come as a surprise to you that we are always brainstorming ways that more automation and better technology in our program would be helpful, would make our work more effective and save us time, but have never had, you know, any funds to invest in that. We might have funds now. Unfortunately, we're really stymied by AOC's freezing changes to anything that involves the court system technology, because we're waiting for e-courts or whatever. So those are things that I think we would like to brainstorm with the budget committee. And the thing we can't do, which would be the great thing to do right now, would be to take funds that are budgeted in the PAC and use it to create positions in public defender offices and shift the work from the PAC to the public defender offices, and know that there's always a transition cost to that. And this would be a great year for that transition cost, but we are not allowed to do that. That requires legislative permission, which we don't have. I must say that, like, I know I say that like 50 times a year, but.
Lisa, we've also been able to use some of this money that we haven't spent to assist PAC attorneys with training. Isn't that correct?
Mm-hmm.
Can you go over that?
Yeah, I have in the advanced packet, I had a, you know, long report of all the sort of actions we took to help both in our own offices and PAC attorneys with costs. So we worked with the school of government to subsidize registration for the trainings that are provided for public defenders, and did see an increase in the number of PAC attorneys who were able to do that at lower cost. We also are covering when attorneys have documented video conferencing costs because they can't go to the jail or other ways or required to do remote proceedings. We've been helping with those costs. That's actually a initiative we have to look at and figure out if we're doing it best. None of those added up to a lot of money, but I'm glad we did it. So
yeah, thank you to the School of Government for working with us on that, because I think we provided some low-cost CLE to PAC attorneys when they weren't necessarily getting paid a lot of money during that time. But thanks to John Rubin and his staff.
Lisa,
happy to do it.
Lisa, can I ask a question? Has legislative authority been requested previously for using those PAC funds for PD positions?
Yes, early and often. The governor usually includes it in his recommended budget. It's always part of our legislative packet. There was a couple of years where we had we thought it came from that there was a couple of years where we had enemies in the legislature who weren't going to give us, didn't want us to be the fourth branch of government. And so this was a great example of how IDS had become the fourth branch of government. But even with that, those feelings, those individuals gone, we just sort of haven't been able to get it back. Anyway, this slide just sort of shows the cost of doing rate increases. Last legislative session, we had a $17 million package, which we called, I think, significant rate restoration. So, because we didn't want to keep saying, oh yeah, 5 million will help, because all it did was chip away at it. And so this sort of shows the full package. I'm just looking at $5 rate increases. Last year, the commission voted when we thought we had new revenue coming in, appropriation, to make priority that lowest rate, that district court $55 rate that's been stuck at 55 since May of 2011. And that's, of course, the most expensive one to address because it's the highest volume. And then what the others are. Some of the higher level cases types, it's not that expensive to do a rate increase, but I assume then you have the concern of deepening the gap between doing a district court misdemeanor that could have serious consequences, doing a DWI. We pay $55 an hour for a DWI. And so having the gap between that and the higher level cases, even though it might be affordable, is that issue.
So that was about little more than $6 million to raise it $5 across the board, right?
Mhm.
Thank you.
And this reflects the two targeted increases that we were able to do, which was bringing the high-level felony rate back up to its 2011 level of 75, and low-level felonies in district court to 60. We had Superior Court at $60 since the drop in May 2011, and so bringing district court felonies up to $60 was not that expensive. That's why, I mean, because that 1.3 million would be doing low-level felonies in both district, superior, and juvenile court. But so that fixing that gap in district court, which I think was significant, was one of the targeted ones we were able to do a couple years ago. My last two screens are about a slightly different topic, the 4E funding. And so I didn't know if I should stop, see if there are any other questions about this before I jump to that.
Yeah, I have a question. Could you give us just a very, very short explanation of what the Cypre awards are?
Yeah, I might be using the wrong legal term. There was a number of years ago, about a dozen years ago, there was legislation that said distributions of undistributed proceeds from class action suits, half go to us and half go to legal aid. I think Ty Hunter was standing at the right place at the right time. So it was, and so some years we have gotten big awards, but we get a lot of small awards. There's a law firm in Winston-Salem that's been doing these great class action lawsuits, because they'll send us a check and I'll be like, can you tell us what it was? And it's usually something that was really, very important in terms of people being taken advantage of by MRI contractors or, stuff like that. So they just show up.
I think there's a bank with the initials BOA that had to pay a lot of money within the last 3 years to that.
And another question is the Center for Children's Rights, that is active only in Mecklenburg County?
Yes, delinquency, juvenile delinquency. Because they do the majority of delinquency appointments unless there's a conflict.
Thank you.
And policy stuff too. And I think they also do involuntary commitments with juveniles. It's a multifaceted contract that we've had a long time. So, anything else on the background and the forecast? Okay. This was listed on the agenda as a separate item, but it's just sort of related, and it's just a long-term project. The federal 4E funds for foster care almost 2 years ago were changed to include reimbursement for representation in those cases for both the parents and the kids. And it's been a long tortured process with DHHS to try to work out the details of that. I think at one time we thought, because we spend $11 million in a normal year on child welfare cases in all its aspects, from representation, initial disposition through appeals, and including our parent representation office. And we thought, getting 25%, 24%, somewhere in that neighborhood of that money is from the federal government was real money that we could even talk about rate increases and things of that sort. Because if we increase the hourly rate for child welfare attorneys, that reduces the amount of funds we'd have to find to increase it for other work in district court. But it turns out there are restrictions on what of our spending is eligible for that reimbursement. It's probably most of our spending, but our ability to document it, because we pay parents, we pay attorneys for representing a parent who might have multiple children at different phases in the process. And in order to claim it for reimbursement, we need to know that those dollars involved a child who was in custody of the county at the time. And so our systems are not set up for that right now. It's a big project, but it's worth it. And we've already been able to bill. We haven't gotten anything yet because we haven't gotten the memorandum of agreement signed, but we've already billed this fiscal year. And I think we might have as much as $500,000 come in this year. Fingers crossed. So that's the good news to add to something else. And Wendy can both Wendy and I can talk at length about how hard this project has been. So.
All right. Are there any questions of Lisa? Any questions? Lisa, is that all you had? I interrupted you. I'm sorry.
No, I just was saying I was just stop sharing my screen.
Okay. All right. Okay. Let me get my screen right here. I think Dorothy had to go and teach a class, so she's going to be back with us as soon as she finishes that class. I think she's listening actually to us if she does that somehow. All right, I'm going to recognize Mary to talk about the legislative session as it gets kicked off, I guess, in January.
Thank you. Before I do that, I just wanted to say that Wendy has some really well thought out plans for what to do with this 4E money. And I look forward to you all being able to hear about that when it comes to pass. All right, the upcoming legislative session, of course, this is the long session, which means it's the budget session, and we'll be getting a PAC appropriation, presumably. I've been talking with Elisa, because this is, my first time working through this process, about how this has happened in the past. And I've learned that there's a very formal process by which you go to the governor's office and make your case for your budget and your PAC appropriation, and a less formal, perhaps more chaotic approach in the legislature. So I really would like to be proactive on the legislative end and look forward to working with all of you to do that. I think that the approach you've taken in the past, which is to ask for enough money to restore rates, right? Reasonable progress toward rate restoration is the right way to go. As Elisa has just discussed in some length, we have a lot of stuff we need to be worried about because of the COVID epidemic and what kind of impact that's going to have on state revenues, and probably an increase in poverty. But I also think that we can make a case that the cost of not acting to raise rates and to fully fund the system is significant. And we have some receptive ears out there. In the last few years, there's been some bipartisan support for some criminal justice reform issues. And even in this little presentation I made to this House committee last month, some of the legislators from both parties who have been involved in JPS appropriations in the past were receptive to and understood and sympathetic toward the rate issues. So we've got to keep pushing ahead on that. I think that maybe there's some opportunity because of fiscal concerns to make some things happen that would save us some money. For example, reclassification of misdemeanors again, and there's some receptivity among folks toward doing that in a bigger way. I'm hoping that perhaps we can get this flexibility that Elisa talked about that we ask every year and is in the governor's budget. Maybe we can really make the legislative side understand how this would help us this coming session. And that's budget. PD expansion, I wanted to touch on that. There's actors in several counties who very badly want and need public defenders' offices, and I expect that they're going to be proactive. And we need to have a plan in place to kind of work to do PD expansion in a way that makes sense for everybody. Prior to me getting here, I know that you all had, or the staff had identified some places where it was logical to expand the public defender office or to add a public defender office. So I think it's important before the session, or before the session goes on too long, is for us to convene a long-range planning sort of committee and have a plan in place for how to ask for or fund or address possible PD expansion as it comes up this session. There's a couple of things, recommendations from these various task forces. I don't know what the legislative landscape is going to look like next year, but for example, I expect recommendations from this governor's task force that I'm sitting on to restore the right of counsel for all misdemeanors, and possibly for first appearance representation, and those things are going to cost us money. So I think they're good in that people should have lawyers when they're criminally charged, but they're also going to cost us money. So we just need to be very tuned into all of that and make sure we have a plan. So that is a very brief discussion of the legislative session. Does anybody have any questions or observations? Because we can move on. We have a pretty full agenda for the rest of our meeting.
All right, any questions of Mary this time? We have some things that we'll be talking about as we go through the rest of the agenda that that have some contact with the legislature. We'll recognize Rob Sharp. Rob, unmute yourself.
Okay, thank you so much. I appreciate it. What I'm going to be, I can't recall how it is depicted on the agenda, but I wanted to just make the commission aware of a situation, and then I'll have a big ask, or at least I'll have an ask and a recommendation at the end of it. In October of 2018, we had a total of 1,478 open cases. So we got about 1,500 open cases. And 16 months later, February 2020, the state had 1,571 cases, or closer to 1,600 cases. So a net gain of about 5.8 cases per month. COVID hits, and due to a lack of dispositions, along with steady and pervasive increases in new cases, over the 6-month period between February 2020 to September 2020, the total open cases went from 1,571 to 1,789. That's a 13% increase over a 6-month period of time, which tracks out to be over a 25% increase if that trend were to continue for a year. The need for qualified capital counsel to take on the potentially capital cases has increased, as you can see. The public defenders are under the same or similar pressures, I suspect, as is Office of Capital Defender. Nonetheless, they have graciously accepted many cases over the past 6 months. I believe maybe even more than usual, and we are exceedingly grateful for our partnership with them. Currently, Office of Capital Defender has 2 attorney positions open. We're going to make at least one of those hires by the year's end. We don't want to onboard 2 attorneys over the holidays. Our 13 active trial attorneys carry 118 cases for an all-time high average of 9 cases, a little over 9 cases per assistant capital defender. Of our 13 active employees, only 4 are below that 8-case number. Roster recruitment remains a priority. As of today, we've got 369 folks on that roster, 25 added so far in 2020, and 23 were added in 2019. 122, or 33%, a third of our roster members have been added to the roster within the past 5 years. To enhance our recruitment of qualified counsel, I sent out a letter to Chief Resident Superior Court judges and have asked all other roster members who have not taken a case within the past year or two to commit to taking at least 1 case. Many of them have politely told me no, but I've at least made the ask. Currently, IDS has a policy adopted in December of 2008 titled Cap on the Number of Open Potentially Capital Cases per Private Assigned Counsel. I described the cap as being a soft cap of 8 with the ability to exceed that number based on various factors that are laid out within the policy. The cap, as the title implies, is only applicable to PAC, private assigned counsel, and not state employees such as assistant capital defenders. While 8 is the cap laid out, while 8 is the cap number laid out by the policy, there exists an internal hard cap. In other words, a number that we're basically not going past right now. And that is the number of 10. So that would be described as a hard cap. That number set in consultation with both the interim and later on with the permanent executive director. And this is where, you know, I need you to hear what I'm saying. The 8 case cap is optimal and provides the absolute greatest protections for our clients, in my estimation. I also believe that as long as our private assigned counsel rate trails the federal rate by more than 50%, and our attorneys make less now than they did in 2011, indeed less than they did in 2002, then recruitment and retention will continue to be a problem. Because we are in an emergency condition, and because I believe that lowering our applicant standards is more dangerous for our clients than raising the capital roster caseloads, and because I understand that you care deeply for our clients, I am recommending that our policy be amended for, let's say, a year to a cap of 10, with the understanding that we will in no event exceed 12. That's for PAC. I'll deliver reports in the coming year to either the commission, or I can speak with Mary and relate our progress and situational development. That's sort of where I'm at. I don't know, since it's your policy, I don't know if we have to even formally make a change because it is not a rule. So I don't know that we formally need to make a change. I invite your questions.
I invite Whitney's opinion with regards to that.
Sarah?
We can hear you now.
Okay, just making sure. This is something that we've been talking about for every year. I really don't know how the change solves the problem, but it may be necessary to get us to a place where we make a true improvement to the
I can't hear.
Yeah, I think you're breaking up so bad, Whitney. I don't know what's going on.
Let me check my network. Can you hear me now?
Yes.
Yes, very well.
I was saying that I don't think that changes to the cap solve the underlying problem, but I do think that it may give us time to continue to work on the underlying issue, which is that we are underpaying our attorneys to do it. And we don't have flexibility with the public defender, private assigned counsel fund, and the public defender office.
I think you're breaking up again. I can't make out. I'm sorry.
Do you want me to try again, or perhaps chat?
Type in the chat box.
That's what I'll do.
Or maybe
Okay.
closer to the microphone.
Where's the microphone at? Maybe that would.
It's right in front of me, and this has not been an issue so far this morning.
It sounds great now.
Yeah, it's just.
It sounds great now.
Yes.
Great.
Yeah, try it again right where you're at.
So in other words, I can't move for the rest of the meeting.
That's correct. Not when you're talking, at least.
Okay. Now that I'm completely and totally befuddled by the technological issues, what I said was I have concerns about making changes to the cap, and I don't think that it fixes the underlying issue, but it will give Rob and the Capital Defense Bar perhaps some breathing room while IDS and the commission work to make fixes, principally in appropriation, that actually correct the underlying problem, which is our ability to recruit at a rate that's at least remotely commensurate with the attrition levels.
What's your position on whether we need to take action on it?
Oh, sorry, I'm getting a little bit befuddled by technology. I was not present in 2008 when the initial cap was put into place. I think that it would be appropriate to make a decision like this, at least on the consensus or the input of the commission. So I don't think that you have to vote, but I do think providing Rob some guidance will give him some protection too if he makes this change.
And I gather that's your agreement too, Mary?
Yes, I do. I think that Rob has appropriately come to the commission for guidance, but ultimately this is within his authority. As
Kate, I saw Kate raise her hand.
Yeah, I was just wondering if it might be possible to think about their recency to the roster. For instance, I mean, a new attorney on the roster who doesn't have very much experience handling 10 potentially capital cases or even 12 seems really concerning. Whereas somebody who is, been a lot more, has handled a lot more capital cases, it would be. So I wonder if you could phase it in for people who are on the roster for a longer period of time, possibly.
We'll address that, Rob.
I think that is a key consideration. I think you've hit the nail on the head, at least of a large part of the problem. But the absolutely terrible other problem is, I know these numbers because it's just a constant thing. We have in Robeson County, we've got 3 assistant capital defenders. They are all at 10 cases or more. We have 3 private assigned counsel. They're all at 10 today, right now. And we have 2 additional PAC, and they just won a judgeship, both of them. And so they're both going to be getting off the roster within the next month and a half with approximately, they're going to take 13 cases, I think, that I'm going to have to reassign somewhere. So I need you to understand, I promise you, I'm hearing you, and I will do my absolute best to not put a newer attorney in jeopardy of messing up a client. What we're trying to do is within your first year onto the roster, we're assigning you a mentor from our office. And it's not a foolproof plan, and it's not, it's not a panacea, but it does at least help, and has helped us identify problems or concerns earlier than the appellate level, I guess, and it's causing us to have really hard conversations with young attorneys, not young, but inexperienced counsel, and say things like, you have to do these things, and if you don't, we're going to have to, part ways, and that doesn't satisfactorily answer your question, Kate. I really think it doesn't, and I really understand that, and I really don't want to be here asking this, or even, but I appreciate the input. I need the input, but it just,
Do you have a sense, Rob, that these attorneys, these PAC attorneys, are willing to take cases above 8 if the policy's changed?
Not many. Not many. That's a great question. Not many. There will be a few. And there are a few regions of the state that are markedly different from others. And Bert's comment is not incorrect. You know, it's a 25-year process that got us here in at least Robson. I think, I don't know how this works. Am I allowed to say, I think Art had a question, or does Darren say?
You're fine.
Okay. Art?
Yeah, just a question. I agree with giving Rob some time to try to deal with this immediate crisis. But my question is a long-term question. What plans do we have to go to the legislature or to whomever to deal with the recruitment efforts that it seems that Rob is, it seems to me that is the nexus of all of this, is not being able to find qualified capital attorneys. So what plans, what strategies do we have to try to address that? I don't know if we need to address that today. Probably not. But I think we need to address that this year, because I've been on the commission now for 4 years. And I have heard this almost every year. The first time I heard it, I'll be honest with you, since I'm not an attorney, I didn't know what the hell they were talking about. But I've gotten much more versed in what's going on now, and I do know what you're talking about. And I think we need to give you some time, but I think we've got to address the underlying issue, at least make it public and make it known, or we'll be in this situation next year and you'll be sitting here saying, can you give me some more blah, 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 blah. And you may have to be there because we may not get it fixed, but I think we've got to have a strategy to at least make it public. And that's my comment.
Well, I think Mary continues on almost a weekly basis to receive correspondence, emails, and phone calls from Superior Court and District Court judges around the state complaining about not just the capital, but the PAC list, because there is a tremendous shortage of lawyers doing this work. And Mary is keeping a file, because I hope that when we go to the legislature, we can open up that file and share some of those stories about this problem.
I've got one just like it too.
And that's one that's in her file.
Oh, okay.
Yeah. Mary?
Well, Staples is raising his hands, and then
Okay. I'm sorry, I didn't see Staples. Unmute yourself, Staples.
Yeah, I have an observation and then a question of Rob. The observation is, and I'm just going to go ahead and say it, the ultimate solution to this problem is the abolition of capital punishment. And I know that may be some kind of third rail or something, but I just think we need to keep that in the back of our minds. And, if we can take an advocacy position about decriminalizing some misdemeanors, I think we should be very cautious about this. But I think that there is something to be said for taking an advocacy position when it's smart to do so, to say, I can save you many $1 million right now. And with LWOP, life without the possibility of parole in the picture, we're not really talking about public safety. That's the observation. The question of Rob is this, and I know this is a little bit of a third rail, but the question is this: is there, you said something about different conditions in different parts of the state.
Yes.
Are there places where there are, let's not call it a surplus, but let's call it less pressure on assigned, capital assigned counsel than other places?
Yes, in the northeast, there is not a surplus, but there's less pressure on those folks. There is intense pressure in the Robinson, Cumberland area, which is why I took a new Hanover position that opened, a Buncombe County position that opened up. Somebody got a job or some different job. So I took his position and moved that to Robinson, and we're doing we're advertising for that right now. In the northeast up towards the coast, terrible pressure on those folks. You know, I've got two attorneys in, I can't remember the name of the county, Halifax, I think is the name, and they're both in the same law firm, you know, and so really I've got one attorney that could take 16 cases, right? Because they're conflicted and I need to consider them the same. We have age going on where I have attorneys who have been doing the work and doing it well for 20 years who are just, you know, moving on, you know, retiring. We hope and pray that's what they get to do. But yes, there are distinct regions in Mecklenburg County right now. Their PD's office has taken as many cases as I've ever seen them take. We have as many attorneys on the roster as I can recall us ever having. And they are all at or above. If they would agree to do 8 cases, they've got 8 cases. If they would agree to do 9 cases, they probably have 9 cases. And many of them have agreed and are doing 10.
We have law firms that are restructuring too and dropping cases. I mean, that's because of the financial problem to the law firm. So
I guess what I'm directly asking is, are there places where, if it were feasible in all respects, that there are lawyers who are underutilized, let's call it, and could accept cases in geographically distant areas? And I understand that's a controversial thing. I'm just wondering.
I like the question. I think there are many who could. I don't think there are many that would. Is sort of, I mean, that's the impression I get talking with them, Staples, is, you know, I mean, there are places where, like there are places where I get phone calls. Hey, do you have a case? Do you have a case? But that was 6 months or a year ago. Now I don't get those phone calls anymore from anyone asking or saying they will travel, or I just don't get that. I mean, I still have to make the ask, but.
Got it. Thank you.
Thank you, sir.
We need to move I'm sorry, go ahead, Mary.
I was just going to say very briefly, Staples, I think times have changed a little bit in that I know there were issues years ago with people coming from out of county. I have judges calling me fairly regularly asking me to help them find people from out of county because the caseloads are untenable for the folks who are doing high level felonies, and it's a crisis. It really is. I think to respond to Art's concern about the legislature, we got to go out and remind them about the cost. Since I've been here a relatively short time, I've looked at, I'm really shocked at how much money we're spending in capital post-conviction cases. We have a death penalty that's never exercised. And we need to remind these folks, I mean, I don't think it's any secret. I'd love to see the death penalty go away. But we need to remind these folks of how it used to be back in the 90s before we had performance standards and caps and people had way too many cases. And yes, people got sentenced to death. We spent all that money to sentence people to death, but they never got executed because they frequently had their conviction or their sentences set aside for ineffective assistance of counsel. So the bottom line is, if they want a death penalty, they got to pay for it, I think. But there's a lot of good reasons not to have it. So that's, I've said my piece on that. I think Darren's wanting us to move on. So,
Oh, I mean, you're the executive director. I'm just
Darren's is moving us along because we have.
Thank you, folks. Thank you so much.
So Rob, I think you can take that you've got our okay. Would that be a consensus to do what you think is the right way of handling it? Because I really feel like, personally, I think you've got our clients' best interest in mind, and that's what we're trying. That's our mission. So
I appreciate it.
Anybody else have any comments for Rob? Margaret's posted a couple of good comments in here that I think you guys need to take a minute and read. And it kind of addresses some of the reasons why there's an eight case cap and things like that. But we're going to move on if we can. Mary, I want you to talk about the Alamance County Early Representation Project, please, and just bring us up to speed on that.
All right, sure. So there was some discussion at the December 2019 commission meeting about the Alamance County pretrial detention litigation. The complaint was included in your materials. IDS was not a party to that, is not a party to that litigation. The plaintiffs had sued Alamance County and the senior resident superior court judge and the chief district court judge, alleging that the defendant's pretrial release policies violated their 14th Amendment rights to equal protection and due process and their 6th Amendment rights to counsel. Now, a consent order for preliminary injunctive relief was entered into in May that required that counsel be provided at first appearance. Before that happened, apparently there were discussions with IDS and with the plaintiffs and with the defendants, and there was an agreement that IDS would enter into contracts for session lawyers to cover district court work. So those contracts were negotiated and work began about the 1st of July. Sometime in August or September, we were asked to cover unscheduled superior court appearances as well. And to make a long story short, I said, I told the folks, well, we agreed to do what we're doing and we're going to do what we're doing, but we're not going to voluntarily do any more. I was prevailed upon to rethink that after discussions with the counsel for the defendants and getting some more numbers on it. And after looking at the relatively low additional cost to covering superior court unscheduled sessions, I agreed to do that through the end of October, pending this meeting and this discussion with you all about this project. Let me tell you a little bit about the cost in Alamance County. So we have several attorneys. We're contracting with them over the first 90 days. We've spent approximately $15,000 to provide counsel for first appearances. Oh, part of the consent decree, they're having first appearances for misdemeanors with 48 hours of them being arrested, or that's the theory. So there were only 6 non-scheduled sessions. So the extra cost that we hadn't anticipated was only about $720. So it's pretty nominal. How's the project working? In August and September, in Superior Court, there were 41 first appearances where people were represented by IDS paid counsel. 3 of them were released. One of the district court attorneys had 109 clients, 35 were released. Another one had 118 and 50 were released. Query whether, I think having counsel undoubtedly helps. Query whether some of this or the improved release rate in Alamance County, I guess they got sued because nobody was getting pretrial release, may also have to do with the pandemic and efforts to keep the jail population low, more people getting citations instead of being arrested. The jail did have a COVID outbreak in August, so that was at the top of everybody's mind. And as part of the consent decree, there's an enhanced process by the judges. They have to make written findings before they impose a bond on somebody. So I do think the lawyers make a difference, but we're not going to know for a long time whether they, how that looks, right? Someday the data will inform us, but not presently. So anyhow, the bottom line is that At this point, I would recommend that we would continue to cover these costs in Alamance County through the end of the injunctive relief period. We signed up for it. It's minimal additional cost. And we can absorb it this year and probably for the remainder of the injunctive relief period. There's a couple of things I think that we all need to be concerned about. One is Alamance County is one county, and we're not doing this in the other 99 counties except occasionally through public defender offices. So if there comes a time where there's a court ruling that requires counsel at your first appearance within 48 hours of being arrested on your misdemeanor charge, we're going to have to spend a lot more money, and we're going to need to get a lot more money. Unless they stop jailing people who get arrested for misdemeanors, which would really be a better way to address the issue. This might be imposed on us by court order. It might be imposed on us by statute. Now, there was a bill introduced last year that would have required first appearances in misdemeanor cases within 48 hours, but the bill was drafted with a specific language defining this is not a critical stage of the proceeding. So that's, I guess, was the legislative drafter's attempt to say you wouldn't have to provide a lawyer. Whether or not that passes constitutional muster, I guess, will depend on what happens ultimately with this Alamance County litigation and litigation in other places. So that's my report and my recommendation, and I'd be happy to answer any questions. Or
we need to take a action item on that, Whitney or Mary?
No, I just wanted to inform you, advise you, and welcome any feedback.
If you haven't had a chance to look at that Alamance County order, especially if you practice, if you're a private attorney at this point in time, I mean, I kind of plug those ideas into what we do here in Rowan County. And boy, Rowan County could have very much have been a defendant as much as Alamance County with the way we handle first appearances and things. So anyway, take a minute and look at that. I mean, it's worth the view. So, all right.
One concern I have, or something that we might need to be thinking about, is that I think if the legislature requires us to provide counsel at first appearances, that they're going to have to give us some money. But I'm a little bit worried about sort of this whack-a-mole approach where they sued Alamance County, and then they sue somewhere else, and they sue somewhere else, and they sue somewhere else. And I'm just not sure that we can step up and do this voluntarily should this come to pass again. So just be thinking about that.
Yeah. Okay. Or we'll be facing another unfunded mandate. We love those.
Indeed.
Okay. You want to talk about the e-courts initiative? I think Elisa spoke a little bit about that.
Yeah, this will be really brief, and e-courts initiative and Uptrust are really related, so we're the same agenda item. I think as most of you probably know, that AOC informed IDS in the summer of 2019 that it would no longer allow changes or enhancements to legacy computer systems, even if they were fully funded by someone else. And our legacy system is the CCISPD system. Thanks, Susan. That's used by the public defender's offices. Now, the public defender's offices will be migrating to the new system being developed through the eCourts initiative over a number of years, slowly, supposedly starting in 2021. And we think taking as long as 5 years. So we're sort of in this holding pattern with our legacy system for a long, long time, which causes me some concern. Wake County is the only county with a public defender office that's going to be included in the first rollout of the new eCourt system, ICMS, right? And that's going to happen, we think, in 2021. And then Mecklenburg County would be included in the next group of counties, which is a little farther down the road, and I'm not sure we have a date on that. Since the time that Tom was notified that AOC would not allow changes or enhancements to CCISPD, AOC has kind of further restricted it, and they're not really willing to do anything, anything that will take IT time unless there's a legislative mandate. which brings me to, even I think new forms, which is problematic and is causing concern, not just to IDS, but to other actors in the system. But that brings me to the next agenda item, which is that we had hoped, I think, that we would come today and Susan Brooks would tell you about how we were getting ready to roll out this nifty new system called UpTrust, where it was a two-way communications platform where public defenders could confidentially text back and forth with their clients. And it would be more than just what ICMS will have, which is a text notification to show up in court. It would truly be a communication system. We were going to get it free for a year, possibly fully funded for a second year. And we were, I think, excited to see how it worked. They have it in Dallas in the public defender's office. The offices that are using it are crediting it with reducing failures to appear and doing all sorts of wonderful things. We requested 8 to 10 hours of AOC time to have them. I'm not really sure of the tech thing. They wouldn't have to do anything to CCISPD. They would merely have to extract data for us so we could get this off the ground. And our request was denied. And, I went back at them and said, well, this isn't a change or enhancement to the system. This is just 8 or 10 hours where you give us information from our system, draw it out of the system. And they said, yeah, we don't have time for that. As everybody who asks for 8 hours, it all adds up, and all the 8 hours are going to put us off our 5-year plan. So I'm not really sure where we go next. There is an appeal to the e-courts committee. My understanding is, although this is from AOC, that the e-courts committee isn't really approving requests from judges or anybody else. After our 8 to 10 hour request was denied, I went back to Susan and to George Tucker, who's our IT guy who works on CCISPD, and with some advice from Margaret, who's pretty smart about this stuff, to see if there was some way we could limit, make a smaller ask, do all the work on our end. And we tried that, and not only did we get shot down again, they basically said, oh, it's what you're talking about. This is crazy talk. This can't be done in 8 hours. Go away. So that's the report on e-courts and UpTrust, and I feel like you'll be hearing more about technical issues and issues that we're having with AOC and suggestions on how to overcome them over the next few months and years and decades, perhaps. So that's my report.
Anyway, something in addition to that.
Yeah, Susan.
I'm not sure it is feasible or advisable, but if we're making big asks to the legislature, mandating that we be allowed to use this trust system with all the benefits it may give our clients and our public defenders and even private counsel, if we could expand it that far, would be really, it's a great tool. And if they're requiring legislative mandate, then maybe we should ask for it.
And I think we will discuss that. And as I said earlier, when we convene our legislative subcommittee of this commission, that's certainly one of the things. Something else that I would like to do before we go and make that ask is I want to reach out to Peg Dorer and some of the other actors who have their own frustrations with this rollout and see if we can't reach it would be different if we were talking about a year or 18 months, but if you're talking about 5 years of inability to make technical advances, that's not tenable. That's not tenable. So that's
before long we'll be using a computer system that began in 1986. Oh, we're already doing that. I'm sorry.
Yeah. So that's my report on that. And I think unless you have questions or comments, we're ready to move on.
All right. Any questions, comments? I want to recognize Sarah. You're still on?
Still here.
Yeah. If you'll talk to us about the statement on diversity and inclusion for the IDS Commission, and you should have this in your packet, everybody.
Thanks. So the IDS Commission Diversity Committee has drafted a proposed IDS Commission Diversity Statement, and it's modeled on the diversity statements of several similarly situated organizations, and it's specifically tailored to the IDS mission statement. and our state's commitment to diversity. So I have, as Darren said, it's in your materials. I'm also going to share my screen so that you can see it in front of you. Give me just 1 second. All right, you should see a copy of it now. And I'll go ahead and just read through it. So because diversity and inclusion are essential to fulfilling the Indigent Defense Services mission, the IDS Commission is committed to fostering diversity, inclusion, and equity in the public defense community. Diversity in the public defense community better ensures fair and just outcomes for a diverse client base. Diversity is an evolutionary concept and encompasses race, ethnicity, sex, age, mental and physical ability, sexual orientation, gender identity and expression, religion, nationality, marital and parental status, and other characteristics and experiences. With greater diversity, we can be more creative, effective, and just, bringing more varied perspectives, experiences, backgrounds, talents, and interests to the practice of law and the administration of justice. We pledge to facilitate diversity in hiring, retention, and career development within the public defense community. We recognize that achieving diversity is a process that requires an ongoing renewal of our commitment to strategies of inclusion. So, as I said earlier, in drafting the statement, the committee took into consideration the statements of several other legal organizations, including the American Bar Association, the North Carolina Advocates for Justice, the North Carolina Association of Defense Attorneys. And then we also looked at some state agencies that have diversity statements, including the Office of State Human Resources, the North Carolina Department of Health and Human Services, and the Code of Ethics of the North Carolina Division of Adult Correction. We believe that the state of North Carolina recognizes that diversity is central to the achievement of high performance, and the drafting of a diversity statement followed by the adoption of a diversity plan is an approach that's recommended by the Office of State Human Resources. This model of first adopting a statement was also followed by the North Carolina Advocates for Justice. They adopted their diversity statement in 2016, and I co-chaired the North Carolina Advocates for Justice Diversity Task Force along with Karani Truzy. In 2017, we developed a diversity plan, and then that was approved by the North Carolina Advocates for Justice Board of Governors. And then after its adoption, several diversity initiatives specific to the North Carolina Advocates for Justice and its mission were then implemented. So the IDS Commission Diversity Committee, we see the statement as a statement of our commitment. And what we propose is that following the adoption of a diversity statement, that we develop a diversity plan, which will lay out the committee's priorities and a roadmap for implementing diversity initiatives that further the IDS mission. We believe this is a defining moment. This is critical to our high performance as an agency, seeking fair and just outcomes for our clients. We seek the input of the IDS commissioners to determine the priorities for the diversity plan. This work is essential to recruiting and retaining public defense attorneys that will seek fair and just outcomes for our clients.
All right. That is a recommendation from a committee, is that correct?
That's correct.
So it needs no second as to but I do need a motion to adopt this. I want to open it up for any questions or comments that anybody has. Any questions? All right.
I have a question.
Yes.
I think it's important. The statement's really important. And I think the plan is the diversity plan that you talked about, Sarah, is even more critical. I'm wondering if we could include that into the statement. I mean, the statement has no teeth. It's a great statement, but I wonder if there could be something to indicate that there will be, that there is the IDS subcommittee, there is going to be a diversity plan that will be created, and there will be data collected, some sort of a little more action item that's included in this statement.
Is that something you would like to take back to your committee and you guys develop some language, or how would you want to handle this, Sarah?
I think we could do that, or we could entertain an amendment to it. Maybe just adding language that we will do this through a diversity plan.
I think that the commission could vote on the statement as amended and and Sarah and I can work on the exact sentence, but that can be added as long as it's consistent with what Commissioner Fenhagen and the commission decides. In other words, if you adopt the statement as amended, including language that IDS will develop a diversity and inclusion plan using statistics and input from the community, we can do that.
All right. And I don't think I have to have a motion because this is a recommendation from the committee, and doesn't need a second because of that. So I just want to open it up if anybody has any more statements or questions.
This is Art.
Yes, sir.
I totally agree that we just do this through amendment and let Whitney and Caitlin and whoever else work on the statement, and Sarah work on the statement to include it in our plan. I was a little bit involved in discussing this when we first did it several months ago now. And I don't think we need to have it lay much longer. This is something that I felt very strongly about since the first day I've been on the commission, that we need to have a diversity plan so that we say that we want to provide, whether we can or not is another whole thing, but we have a commitment to providing diversity in our public defender workforce. I simply say that when we see our clientele is of such a nature that we need to at least try to work on that diversity. Those are all my statements there, and thank you.
Okay. Anybody else briefly? All right. So I'm going to put it to vote. All in favor of adopting and approving the IDS Commission diversity statement that's listed as a draft at this point in time, with the added language that will include that there will be an action plan put in place to adopt or to see that this mission goes forward, and to allow Sarah and Whitney to do that. If you'll indicate by saying yes on your chat or on your on the participant bar, and if you disagree, vote no, please. You'll vote now. And Whitney, if you'll just announce the whether that's passed or not.
We have 6 yes right now, no no's.
Everybody voted or can't vote, or if you're having trouble, let us know.
Sorry, I just lost my participant.
I'm sorry.
Something happened and I lost my participant screen.
I see 7 yeses in the participant screen and no nos, and I don't see anything in the chat box. I think we had more than 7 commissioners on, but I do know Dorothy had to drop off, so that might be everybody.
And this is my first time ever being on a Zoom call, so I hit yes. Now, I think that should be it. I shouldn't have to hit yes and send. You know? Okay.
That is correct. And I had the participant list open showing who had voted yes, but with 7 yeses, that's a majority. And we can say that the statement subject to the amendments suggested by Commissioner Fenhagen passes.
All right. Thank you, Sarah, for your committee and the work of the committee and for your work on that. The next item is the adoption of the 2021 meeting calendar, and that should have been in your materials. I think after Whitney had her Ouija board out and all those other things to try to figure out when we could have 4 dates where the majority of us could get together, we do have those. Whitney, I don't have that in front of me. Will you name those dates right quick?
Yes, I will. Just give me 2 seconds to go back to my packet. Sorry, just one more second. The dates proposed are January 22nd, 2021, April 9th, July 30th, and October 29th.
All right. So do I have a motion to adopt those dates for our meeting calendar?
The vote panel has been cleared, so if you want to submit it for adoption.
I'm sorry. Did you say something, Whitney? Oh, okay. All right. I got a motion from Staples. Is there a second to that? I can't see all of the screen. Okay, Art. All in favor, if you will hit yes on your participant screen. Mary has accused me of being a person who has a glass half full. So I'm hoping that we will have a in-person meeting in January. I'm crossing my fingers. So, and I'm not going to say how I really feel because I don't want to spoil Mary's thoughts about me. So
I am also a glass half full person, and I am thrilled to have a glass half full chair for this commission. So
thank you. All right, here's the most important item in the business here is that we need a strong vice chair for this commission. And I will throw out that you're stuck with me for another year, whether you like it or not. And we have a great vice chair right now, and I strongly support her nomination and election for vice chair, and that would be Dorothy Hairston Mitchell. And so I would ask for a motion to elect Dorothy as the vice chair. Do I have a motion?
So moved.
All right. Do I have a second? I've got a second. I got 3 seconds. All right. All in favor, would you hit the yes mark, please? If you are saying no, then don't vote. So, no, just kidding. All right. Congratulations, Dorothy, wherever you are. That's what usually happens when the person doesn't show up for the meeting, they become president, right? All right, other business. Mary?
we have some business in executive session. Whitney, remind me, and I should know this off the top of my head, the FIAP issue, is that addressed now, or is that addressed that's addressed now? So the other business, in your materials, there is a fee application from, and now I'm scrolling down to try to find it.
Walter Paraguay.
I'm sorry, I didn't hear Whitney.
You're unmuted, Whitney.
Yeah. Did you find it, Mary? It's from Walter Paraguay.
It's from Walter Paraguay. His fee application was submitted out of time. Now, people can submit fee apps out of time with a request for me to forgive them, but this was submitted too late for me to do that, and it needs to be addressed by the commission. This gentleman's office was flooded and his records destroyed during Hurricane Matthew. I think he puts forth a compelling case to the commission to have you all waive his tardiness in submitting this fee application. And
right. That's an action item. Is that correct, Whitney? All
yeah,
right.
You need to approve the waiver.
So moved.
Is there a second to that? All right, we got a second. All right. All in favor, if you'll hit yes, and if you vote no, hit no. Essentially, you have 1 year to get your applications in, and this gentleman had lost all his files and basically located this one, so in the hurricane. So,
okay.
All right, that pass.
We're at 6 yes.
All right.
7 yes, we're good.
Good. Okay.
Yeah, I don't typically vote unless we need it, but I'll.
Yeah.
All right. Okay. Also, Whitney, this is a good place for you to do the reminder for the State Ethics Act requirement.
Sure. Am I unmuted?
Yes.
The commissioners are subject to the provisions of the State Ethics Act, and that requires each of you to yearly, around, I think on the same day your income taxes are due, submit a statement of economic interest, the SEI. The first one is kind of laborious, but following that, you can do a short form report. You also are required every other year to take ethics training. It is a bit dry. It is not something I would call thrilling. I will tell you that I have done it both online and in person. There's nothing to be gained by doing it in person. I try to send you reminders about both periodically through the year. And it is very important that you do both, and you do both in a timely fashion, because the commission is not without teeth. They can fine you for late SEIs, and they can even decide to remove you from a commission if you continue to fail to comply or to respond to them. So I encourage you to be mindful of that when you get my little nudges about taking your training or doing your SEI. Go ahead and do it. The commission, even before the pandemic, had made efforts to make as much of this as electronic as possible, including an electronic filing of your SEI and numerous webinars for the ethics training that you're required to do every other year. Technically, if you're in non-compliance, you should not be able to vote on a commission decision, and ultimately the Ethics Commission could decide to remove you from whichever board or commission you've been appointed to.
So do your training and do your ethics.
Art, did you have a question?
Art.
I just wanted to make a comment that I appreciate your reminders, Whitney. I went on last week and I tried to do the training. It was very difficult. Don't do it in, of course you can't do it in Google Chrome at all. I tried to do it in Firefox. Firefox did not work at all, even though they said in the instructions to do it in Firefox. The only way you can get it to work is using Internet Explorer, and it is not the new Internet Explorer. It is the original. It's not the Microsoft Edge Internet Explorer. It's the Internet Explorer period that can get it to work without any difficulty. That only took me about 4 hours to figure out.
And it's a stimulating 4 hours too, so.
I'm very sorry about that, Art, and I have a good contact at the commission, can ask her if they have, a kind of canned guidance or instructional response that they send to people who have difficulty accessing their online programs.
No, it's fine.
It is not stimulating. I'm sorry. Darren is being glass half full. The first time I think it's interesting. So Brian, Gus, you have that to look forward to.
No, it's not. Do we need to do the quarterly misconduct report right now too?
Yes.
Only if, yes,
No.
and I've
No.
prepared the quarterly misconduct report for you. There are 2 names on the report, one of whom, the second, is a contractor, and Tucker Charge as regional defender is very much on top of that issue and working with the attorney. The first one listed, Mary and I have discussed, and we've discussed it with Darren and Dorothy, and our intention is to reach out to the 2 public defenders in areas where Mr. Allen practices, and make sure that their indigent appointment committee are aware of the suspension and monitor it when and if he is readmitted at the end of 1 year. The nature of the allegations are alarming, and are particularly alarming, I think, when you think of somebody who provides representation to a vulnerable population. If the commission would like us to take any further action, then now would be the time for the commission to provide us some additional directives.
All right, that's for informational purposes. Does anybody have any questions of Whitney with regards to that? All right. Okay. At this point in time, I would entertain a motion under North Carolina General Statute 143-318.11 subsection 3 to go into executive session for the purpose of the commissioners to meet with their attorney, Whitney Fairbanks. Do I have a motion for that? Art, second. Staples, all in favor, hit yes, please. And then we'll have to take a few minutes and I think that passes. Is that correct, Whitney? I think it takes, we need a few minutes to get rid of everybody but the commissioners and Mary and Whitney.
Yeah,
Mary.
it's 12:12 now. I don't think I can get through the executive session without taking a 5-minute break. So maybe, and it's going to take some time to do it. So maybe we should reconvene at 12:20. Would that work?
Yeah, let's that we can take that break while we're getting rid of everyone.
Yeah, I think.
Yeah. So
bye, folks.
Thank you, everybody. Bye.
You guys can certainly stay around and jump back on.
Yeah, Whitney.
Really
yes.
don't want to. You guys have a lot of important things to do. I don't want to interfere with that, Darren. I think
Dorothy, I want to tell you congratulations. You're the new vice chair again. So, or not the new one, but you're the vice chair.
That's what you get when you leave the room.
I was teaching class. Y'all have to forgive me.
All right, we're taking.
Thanks.
Here, thank you.
What are we taking? 10 minutes? Okay, that's a good break for me too.
10 minutes. Olivia,
Yeah.
we're taking a 10-minute break, but you can go ahead
7
and
minutes
stop
now.
live streaming now.
Okay.
7 minutes.